afternoon. I'm Jana Martin, Chief Executive Officer of the American Insurance Trust, known to most of you simply as the Trust. We are delighted that you're able to join us virtually today for the next webinar in our virtual webinar series. The Trust is pleased to be able to offer this informative content free of charge to our policyholders. Most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of our many benefits that our policyholders receive through the Trust. Three of our advocates are with us today, Drs. Joe Scropo, Daniel Taub, and Lisa Bryant. This virtual webinar will earn you 1 CE credit. This can be combined with 5 other risk management credits to save up to 15% on your Trust-sponsored professional liability insurance policy. I hope everyone learns a lot over the next hour. Please join me in welcoming our esteemed presenters.
Great, thank you, Jana, and welcome to everyone joining us. Glad to be here with you, Dan and Joe, as well. So we're gonna, as usual, due to time, we're just gonna dive right in, and as we normally do, we have a few questions we're gonna start with that sort of come from either leftover questions last time or things people have asked us in the interim. So we'll dive into those first and then jump right into the questions on the Q&A box. So the first question that we have here, and Joe, I'm going to start with you on this one, is are there any immunities that may protect practitioners from malpractice suits during the COVID pandemic?
Okay, good question. I think this is an important one. There's a lot of debate about this at this point in time. Let me just take a step back and say, what is an immunity? An immunity is a waiver from the government that says that suits cannot be, civil suits, malpractice suits, or sometimes criminal suits cannot be brought against a provider during a specified period of time under specific circumstances. So normally we're all subject to being sued, and there's no immunity for us generally. So why would there be an attempt to have immunities put in place? But the rationale is that in order to prevent people from not providing care out of fear that they're going to be sued, an immunity will keep the healthcare providers working and out in the field without too much anxiety about making a mistake. The other issue here is that there isn't a clear standard of care when in this particular moment. When you get sued, or if you do get sued for malpractice, you're judged by what's called a standard of care. And that's what a reasonably prudent ordinary psychologist would do in your position. And if you deviate substantially from that, then you're exposing yourself to a successful malpractice. But in the middle of a pandemic, we have no history of how psychologists or mental health providers would operate. So we don't have a standard of care, or at least only one that's beginning to emerge now. So the rationale here is that until that standard of care gets formalized, and we can agree on what that is, what's expected from practitioners, we need a window period where providers are going to be free from suit. So that's the concept behind immunity statutes or immunity provisions. There are two levels of immunity. The first one is the federal level, which would apply both to federal level of action and state level of action as well. The problem with these immunities is that they apply only to volunteers. So in order to get the benefit of the 3 different federal immunities, you're going to have to be working gratis, pro bono. And sometimes you have to be affiliated with a volunteer organization or some other non-governmental entity that's trying to help. So if you're in that category, that's great. Then you have immunity under the federal law, and that law supersedes state law. So for people who are volunteering to help COVID in a COVID-related situation, there is good federal protection. the majority of regulation of malpractice suits, however, and of healthcare generally, occurs at the state level, and that's where things really matter. And I'll go through some of the immunities that states have. All 50 states have what's called a Good Samaritan immunity, so that if you happen to be walking by or driving by an emergency situation and you stop and you gratuitously try to help without cost or benefit to yourself, there's an immunity there. And that you can see probably applies more to physicians than to psychologists. But there have been 16 states that have added COVID-related protections, COVID-related immunities. And they vary in terms of what they cover. So some of the variables that go into these state immunities are which professions are covered. Are psychologists covered? In most places, psychologists are covered where there are state immunities, but in some states they're not. A second variable is whether the immunity applies to all healthcare that you give during the public health emergency or only COVID-related care. The rationale to make all healthcare immune for a period of time, all healthcare providers immune, is that the demand on the system is stressing all healthcare. So all the healthcare providers need some window, some cushion period here. There are 3 states that have granted almost complete immunity. That would be New York, New Jersey, and Maryland. And this is particularly related to COVID and applies only during the public health emergency. But in those 3 states, you have considerable protection. Now, let me say something about the extent of the immunity. The immunities generally are for just what's called ordinary negligence, meaning regular malpractice. And what's generally not covered by immunity statutes or orders is willful or reckless disregard for the care you're providing. So none of these immunities will cover things like being drunk in a session or doing something so gratuitously wrong that there really is no justification for it. Mm-hmm. So it's important to bear in mind that this is not carte blanche. My advice to each of you would be to look into your state, maybe through your state psych association, and find out about the immunities. And try to be clear as to whether it covers your profession, what kind of care it would immunize you against. Does it have to be treating a COVID-related issue, or can it be any kind of health care? Third, how long will the immunity be in effect? Typically, it's going to be for the duration of the public health emergency. And you also want to see what's covered. Is criminal acts immunized against civil acts? What particular issues are you protected from and not?
Mm-hmm. Great, thank you, Joe. That was really comprehensive. Dan, do you want to add anything?
No, I think Joe covered it, Lisa, in terms of the immunities. These are really interesting developments and really an attempt, in my view, to reduce, as Joe was pointing out, the stress for providers who want to step in and do something, but they're not absolute, of course.
Mm-hmm.
Yeah.
Right, no, I agree. Okay, so a related question, but slightly different, that we're getting is, are there risks then of licensing board complaints in the event that someone alleges they contracted COVID from in-person care? And Dan, do you want to start with that one?
Sure, thanks, Lisa. As Joe pointed out, this is the immunities are for civil actions. They typically, and to my knowledge, do not apply in any state at this point to licensing board procedures, which are significantly more likely to happen if there's going to be any legal action. And I want to preface this, by the way, by my sense that it's not that there's a huge risk here. There's just some increased risk, okay? So this is not intended to send you running for the hills, all right? But one of the reasons, among other reasons, for licensing board actions to be easier is, if you think about it, a malpractice case, a standard civil case, the most plaintiffs, which will be unhappy patients, are going to have to retain an attorney. And that attorney is going to have to say, first, there's enough damage here that something really awful happened that it's worth suing. And that could be the case. You know, there are significant risks, but do recall that most people will recover from COVID. Often it is not only not fatal, but it's mostly inconvenient for a matter of, you know, weeks or perhaps a few months. So the attorney is going to have to look to, is there enough to sue for? But then another significant hurdle is, are they going to be able to prove that there's causation more certain than not? And if you have a patient who goes to your office, but they also went to the hairdresser before they came to you, or to barber, and then they go shopping afterwards, you can see the challenge in proving that your office was the one that caused or gave them COVID. So hard to get an attorney to say, gee, I'm going to be able to put in all this time, effort, and money and make a good profit on this, because that's part of the decision that a plaintiff's attorney has got to make. So it's less likely that that will happen. On the other hand, a board complaint is easy to make. You either make a phone call to the licensing board, or you go online and visit their website and you fill out their form. And then the machinery of the state is activated, it's brought into play. And boards not only look to their regulations, but in a number of states, they also look at the APA ethics codes, which in many states are either advisory or in fact mandatory. And if psychologists' actions vis-a-vis COVID are seen as a threat to public health, and we haven't complied with recommended standards, for example, it's not too far a leap for the board to determine that because there's a potential for harm, we didn't abide by our ethical standards or regulatory standards. Also, as most of you are aware, if a licensing board opens up an investigation, they can look at anything the psychologist has done. They are not limited to the allegations themselves. And so licensing board requests my paperwork and my informed consent form. I provide it and they deem that it's insufficient according to the regulations, then I could be found responsible for violating my statutes or regulations in my state. So though immunity clauses have been passed, unless they specifically include, and to my knowledge none do, licensing boards, there is an increased risk of a licensing board complaint, and there aren't the additional protections that Joe was speaking to a few minutes ago. But do be aware that even though there's an increased risk, it's still not very high. One, however, is wise, I think. It's prudent to consider, okay, how do I manage that increased risk? And what it comes down to is a careful approach to in-person services that follows CDC guidelines, federal guidelines, state guidelines, and state requirements. So public health officials in many states have put out guidance. Some states, like New York State, has developed an especially thorough and clear set of steps for reopening and coming back to in-person. If we fail to follow those rules, then I think if there's an adverse event, it's more likely that we'll end up having a board discipline us if indeed there's a complaint made. So what that means is that if you're following the local guidelines or regulations, as in New York's, or rules as in New York State's case, and the CDC, like social distancing and masks and barriers, plexiglass barriers, and you've been able to demonstrate that you've taken those actions, your risks for an actual finding against you go down. And I think they go down pretty significantly. Also, as many of you have attended before our roundtables, you know that we've been making recommendations for a few months now about making sure that you document that each of the patients or clients you see is suitable for in-person services, that you document an ethical and a risk management analysis that weighs whether there's a well-articulated justification to see the individual or the family or the couple in person, okay? And if you do that, again, I think that the ability to manage the somewhat increased risk is strengthened. A footnote here, though, and that is, you know, because things are so uncertain, as Joe mentioned, as regards the malpractice standards of care, I do think it's going to be generally harder for licensing boards to say, what should people be doing? And what they're going to do is likely look to, well, what are the guidelines that are out there? But where they might run into difficulty is if the state doesn't adopt APA ethics code, the state does not have specific rules that have been in place for going back to in-person services, it may not be so easy for them to say that we have fallen below the ethical standard or the regulatory standard. So it's going to be not a highly likely scenario in some states that a board's going to be able to find against us, or in this very uncertain time.
Mm-hmm. Great, thanks, Dan. Joe, any addition to that?
Yeah, I would just add that we're mostly talking about the risk of patients contracting COVID when they come to our office. That's the primary immunity that we're concerned about. But there are other COVID-related risks. So, for example, doing a procedure, doing psychological testing, that because of the adaptations that you have to implement because of COVID, lead to a non-standard result, let's say. And that could be a basis for being sued for malpractice. So the main risk is people getting sick in your place. But there's a kind of domino effect that as we adjust and change our practice, there's going to be changes in the techniques and things and recommendations that we make. And those too could also be the source of malpractice suits. So that's where the immunities really help out as well.
Yeah, and that's a good point, Joe, because I think too, you know, those are also potential reasons for board complaints as well. And although I personally, and I don't think you guys can, but please jump in, I don't know of any, thus far, any board complaint made because someone got sick from COVID. But I have heard of some complaints being made based on, you know, different things that a clinician might do related to maybe making recommendations or recommendations that go against CDC guidelines or things like that. Other sort of clinical judgments that might be made, those can be the basis still for licensing board complaints and or suits. What do you guys think on that?
Well, you know, it's interesting. I've only had one question or one person call about a potential complaint because of a youngster apparently getting sick and somebody being vulnerable in the family, but it hadn't progressed yet. So, you know, hundreds of calls that we all have received in the past few months, nearing thousands, that's a low incidence rate. Yeah, I think that's right. It's not, you know, not likely.
And just one other thing, the standard, Dan was saying that it's difficult to prove that someone got COVID in your place. But it's important to remember that the standard of proof in malpractice suits is just a preponderance of the evidence, 51% of the evidence weighing in favor. So it's not, you know, all that needs to be shown is that it was more likely than not that it was your place. So I wouldn't rely too heavily on the difficulty of tracing causality as a way of dismissing the risk here.
Yeah, so I think maybe the take home is, you know, there is some increased risk for potentially both suit and licensing board, but that risk may be not giant, might not be really big. And the best thing to do, you know, some of it is still unknown because the whole pandemic is unknown. So in the face of that, employing some of these techniques we've talked about, risk management strategies, with good informed consent, good documentation, all of those things, that's, I think, maybe the best we can do at this point. And I do want to just mention, for those of you, if we haven't mentioned it this time, we have before, but there are those resources on our website. We do have, for instance, a sample informed consent addendum specifically related to returning to in-person services, things like that. So please definitely go and check those out if you haven't already. Okay, next question, and Joe, I'll send this one back to you. Can you comment on some of the potential legal changes to the healthcare system, primarily with respect to telemedicine, that are likely to occur or maybe have occurred as a result of COVID?
Sure, yeah. Probably, as most of you are aware, there's been a relaxation of rules regarding primarily telehealth. Both at the federal and the state level, in most state levels. And there's been a huge increase in telehealth. From the last week in April of 2019, there were 13,000 billed Medicare telehealth services provided. The same week here in 2020, there's been 1.7 million such encounters between providers and patients. So there's been a phenomenal increase. And I think we're all getting adjusted to this idea. Many of us, had sort of thought in theory of telemedicine or teletherapy, but until we were forced to do it, which is what the pandemic did, we didn't really have that much experience with it. So we're finding out now on the fly whether this works and whether it doesn't, or when does it work and when doesn't it work. So the changes that were made at the federal level were to allow Medicare patients to get teletherapy no matter where they were. It used to be that Medicare patients had to be in a rural setting in order to qualify to receive telehealth services. That was removed in the pandemic. There was a relaxation on the kind of platforms, the video platforms that could be used, so that Skype and FaceTime became acceptable as well. And finally, a little bit into the pandemic, Medicare finally said phone. Okay, phone is good, whereas phone was never reimbursable before. And that's turned out to be a huge boon, because a lot of folks on Medicare are older, they're not technically sophisticated, and they don't have access to good internet necessarily, or internet devices. And miraculously, we discovered that, hey, there's a phone, and the phone works. So that was another change that went into effect, as well as parity for reimbursement between telehealth and face-to-face sessions. So there were many changes, and now the question is, do we want to preserve them? When I say we, I mean us as a society, the government. Do we want to preserve those changes or not? There appears to be a fairly strong push to solidify many of those changes, so that going forward we can continue, and which would be good. In other words, we'd be able to get reimbursed for the service. There wouldn't be any penalty. We could use different devices to do it. We could use the phone if necessary. The downside, though, the argument made by other folks on this issue is that we don't really know how much fraud and abuse this may open up. There's a kind of theory, and I don't know whether it's true or not, that telehealth or teleservices are somehow more prone to fraud and abuse. And also, there's a question of efficacy. Is it really working? So HHS and other entities are looking at these things and trying to decide which ones to make permanent. The other issue here has to do with, and it's still unclear as to the extent to which providers and patients like telehealth. So there are folks who patients who love it. It's so much easier. You just get up, you go to your computer, commute, and it's easier. And there are providers who feel the same way, that it's less overhead, less office overhead, easier to do. They find it less stressful. They can save time. But on the other hand, there are patients who hate telehealth and don't feel like it's the same as being in the room with a person, and providers who also feel the same way. So this may be a function of the certain kinds of persons, certain kinds of providers who are inclined one way or the other. But that's going to have to play itself out as well to see what, in the long run, what patients like and how much they like telehealth, and the same for the providers as well.
Mm-hmm. Right. Thank you, Joe. And I think we talked a little too, like some of the cost sharing pieces, right, for insurance, some of those are still in place, but we don't know if that's going to continue either. So there's a lot up in the air. And Dan, if you want to jump in here, that's great. But I'm noticing the time and I want to keep us moving so we can get to the live questions too. So do you want to jump in or do you want to?
Why don't we just move on, okay?
Oh, okay, great. So the last question then before we start taking the live questions is, what ways will SIPACT affect remote practice for both those who are in SIPACT, like a member of it, and also those who are not, who are outside of SIPACT states?
So, it seems like Lisa, the simplest solution would be or would have been for the federal government to step in and say, we're going to pass a law that requires there to be national licensing. But because of political barriers and at least arguably constitutional issues over the course of many years, it just has not been feasible. So states have stepped in, as I think many people in our audience know today. And they've stepped in based in part on a solution that's been around for a few hundred years now. And that's developing what are called compacts. Those are formal legal agreements between states. These formal agreements require that each state go through its own political process. The bill is introduced, the legislatures come to some compromise, pass a bill, and then the governor signs it, and that they join the agreement in a formal fashion. The particular kind of compact that has been related or is related to psychological practice is SIPACT. And the Association of State and Provincial Psychology Boards developed a model legislation and has been working with many licensing boards and legislatures around the country. And as of July of 2020, the 1st of July, SIPACT became a legal reality. It currently has 14 states in it, although 2 of which are not, they don't have the legislation active. The laws have been passed, but they don't go into effect until the 1st of January for Virginia, and then North Carolina the 1st of March in 2001. Among other things, SIPACT permits, when your state is a member, unlimited remote practice in all of the other states that have signed the agreement. And if you get a particular credential called an e-passport. It also allows, if you get an interjurisdictional practice certificate, up to 30 days of practice in person in the other states, not one's home state. Just so you know, things are moving pretty quickly. 14 states have clearly passed legislation. There are 13 currently considering passing legislation this year. Now, a few conditions, and there are many, and there's lots of ambiguity in all of this, but if I am a member of a SIPACT state, let's say I'm in Utah, which is a member, and I'm licensed in Utah, I have to be in my home state in order to practice with that e-passport. So in the other states, okay, in all the other now 13 states. As you can see, this really expands tremendously the population with which a particular clinician can work. And it's been very helpful, I think, during COVID, will be really helpful, has lots of potential benefits to it. Like all changes, there are some downsides. Among those are, for example, that there, this really creates kind of a two sets of standards, or actually more than that, but generally 2 sets of standards. If I am not in a SIPACT state, which in my case is the case, then I can't engage in getting the e-passport, nor can I practice in these other SIPACT states under SIPACT. By the way, the e-passport right now is free. They've waived the charges during COVID. So this may be a good time for those of you who are in member states right now. Also, what if I am in a SIPAC state, but I want to work with a patient who has moved to a non-SIPAC state? Well, this is interesting because it hasn't, in that way, hasn't really changed around temporary practice rules in both SIPAC and non-SIPAC states. SIPAC states seem, and this may change, but they seem to still allow temporary practice by folks not licensed there or not members of SIPAC. So as an example, Colorado continues to, and their SIPAC state continues to permit practice for up to 20 days in a calendar year, as long as the clinician lets the patient or client know that they're not licensed in Colorado, okay? And so a number of states still permit this alternative method of practice, but of course there are some limitations. You have only a temporary basis within which to practice, and you are essentially having to get to know what each of the non-SIPAC states would require if you're intending to practice in a legal fashion. My sense is, Liesl, that what's going to happen is we're going to see more and more states passing these laws. With 13 states considering legislation, there's a good chance that anywhere from 6 to 8 of those by the end of this calendar year will have passed legislation. And that puts us getting close to half of the United States being participants. Not all states will be on board for the long haul. And part of that has to do with that in some of the larger states or populous states that have not joined on, they're concerned about competition and the financial impact of some practitioners from, say, a rural state where the cost of living are a lot lower, practicing in a state and in a city like New York City, where the cost of living are among the highest in the country. Okay, so I think we're going to see a real change here, and it has been more rapid than I have anticipated, but it's not going to be uniform yet.
Mm-hmm. Yeah, Joe, any quick comments on that?
Just that, as Dan alluded to, there's a lot of the intricacies that have yet to be worked out in terms of which laws control your state, the receiving state, and other kinds of concerns. So I think we're going to have to see it evolve and improve and rise to the task. So it's exciting and it's a good thing, but I think we have to be cautious as we get into it. There's going to be some unexpected bumps in the road. Mm-hmm.
Yeah, and a good idea too to be, for those who are joining, and I myself am in a SIPAC state, although I have not yet gotten an e-passport, but very important, I think, to be aware of what are the regulations that SIPAC is putting out and how does one practice under that, and being knowledgeable of that before just jumping in completely. So, okay, well, I'm noticing the time. I think we could talk a lot about some of the complexities of SIPAC, but let's jump over to take some of the Q&A questions, and then we'll see if we end up back on that topic. One, this might be a relatively quick question, and is there a free and HIPAA compliant way to receive electronic payment from clients? Dan, you want to jump in on that?
Maybe. Because, well, the reason I say maybe is that the problem here, Liesl, is that whenever a payment service uses what's called, or engages in what are called back office activities, which are sending invoices, receipts, it implicates HIPAA. And so many of them that are free will not sign business associates agreements. They will not say without you're paying something. The ones that will sign business associates agreements have generally charged. Okay, and so I'm saying maybe because if you can limit some of the free ones to not giving any other information, but simply you bill through them, then you may be able to proceed. My own view in this, and there are reasonable minds differ for sure, is that the safer option is to pay for it because you do get what you pay for. And I worry, as has happened in some of the open services, that sometimes they change their privacy settings without telling you. And now people are seeing all kinds of information that's listed, for example, in Venmo, when you thought you had your privacy setting set, and now they're seeing a list of 82 patients you have been interacting with on Venmo. So I think a conservative way to go is you pay, but it's possible that it could be without payment.
Mm-hmm.
Yeah, I would see it. I see it a little differently. I don't think HIPAA really applies to pure financial transactions, as long as it's just a monetary exchange between a provider and the recipient. But the free services that I'm aware of, Venmo and Zelly, I think, they're free, and they often run through, or at least some of them run through banks and transfer money through banks. Which again, I don't think raises a major HIPAA issue. But what we've gotten calls on is that people don't know how to configure the system, the Zelly or the Venmo or whatever it is, and inadvertently, because they don't know how to set it, end up distributing the entire list of patients to everybody who's on their client list. So I would say if you're careful, if you're careful and you practice methodically, the risk is probably manageable, but you may want the extra security of something that has greater layers of protection in case you do make a mistake.
Right. No, that's great. Okay, another question. Do you have best practice recommendations regarding use and documentation of chat function within Zoom or similar teletherapy platforms? Would you suggest turning off this feature? And if not, would you suggest keeping full log of chat or including summaries in session notes? And Joe, do you want to jump in on that first?
Yeah, sure. That's a fascinating question because it's something that is unique to video therapy, that along with the video, there could be some written communication back and forth. It's a misconception that everything that occurs between a patient and a therapist has to be noted, has to be recorded. What your note has to reflect is an accurate summary, an accurate depiction of the service that's been delivered. So I wouldn't say there's an obligation to preserve chats or written exchanges during video, but if they're significant, if they contain significant information, then it should go into your notes as to what occurred. So less important than preserving the words themselves is noting the clinical content, especially if it's relevant, and documenting it. I think if you do that, you're going to be okay.
Mm-hmm.
Yeah, I agree. That's a great point. Dan, any addition?
Yeah, well, just, I agree with Joe. I also think, keep in mind there's a distinction, folks, between a chat during a session and the emails and texts that you get, and perhaps even IMs outside of a session. And generally, I would encourage you to keep those. Those are communications with patients. Again, you could do record keeping of them, but often they turn out to be important just to make sure you got the emails in your chart. Very different than when you're doing a session and you're going to summarize it.
Mm-hmm. Great. Now, here's an interesting question, and I imagine this will be coming up more and more. It says, once we have a vaccine available, we obviously cannot make clients take it. So is there a guideline how to approach or handle those clients differently for health and safety reasons? And this, as you can imagine, will be somewhat complex. Dan, do you want to jump in on that first?
Sure. Well, I think this comes down to having a very engaging in a good conversation and good informed consent with the client about the risks you believe they're taking. The clinician themselves being both mindful of risks for themselves, but if they have, they've taken the vaccine and they don't have much concern, or there's somebody who has antibodies, then they may say, okay. There's also, of course, the issue of potential risk to other patients if it's communicated because somebody comes into the office. So the clinician also would be wise to consider, should I continue with this client remotely? if they're unwilling to get a vaccine. And I don't think there's a clear cut, you can't do it. I think you could continue because, as is happening now, many folks are doing at least some limited in-person services and following a variety of the guidelines that are put out there, and we don't have a vaccine. I think this is going to evolve, Lisa. I think we're going to have to see, what the standards are and whether it's considered reasonable to have somebody come in who has not taken a vaccine or used the vaccine, if indeed all of those other hurdles that we were talking about before can be surmounted by a plaintiff's attorney, what it would look like for a malpractice case, or indeed what a licensing board would say. But I don't think it's going to be incumbent on the clinician to always say no or to do a medical evaluation. It'll be incumbent to use appropriate protective measures and to make a considered decision in each circumstance.
Mm-hmm. I think it's interesting because, unless the vaccine is mandated, no doubt there's going to be people who say, I don't want to take a vaccine. Mm-hmm. And Joe, any thoughts you want to add?
Yeah, I mean, I think that a lot of this is going to have to play out as the vaccine develops, as we get knowledge about how efficacious it is. And I suspect there'll be government regulations mandating vaccines for at least certain groups of people. And so to some extent, the question will be answered by that municipal guidance or municipal rules and laws. I think if someone tells me as a patient they refuse to take the vaccine, I am either going to do telehealth with them or I'm going to assume they're contagious and use universal precautions if I am going to see them face to face. But as I said, I think a lot of this is going to be addressed by the laws and regulations they're going to follow as soon as there is an effective vaccine.
Mm-hmm. Yeah, so we'll have to stay tuned like many of these things, right?
Mm-hmm. Yeah.
Okay, another question says, I keep paper files and have been writing, quote, telehealth via secure video due to COVID-19 client in home, end quote, at the beginning of each note for the past 6 months. This is cumbersome, and I'm wondering if I can condense it. If not, I'm creating a stamp. Can you guys give some guidance on what is necessary in terms of documentation, how we might streamline some of this? And Dan, do you want to jump in on that one?
Sure. Yeah, I mean, I think it's important to note and actually ask each session in telehealth where your client is, where your patient is, for reasons that many of you know, for emergencies, crises, and so forth. And to document that you've asked. Can you do it in a less cumbersome way? I think so. I think that may be one of those, you can check the box. If you have a form, you can do that. But I do want to mention around checking the box that it's important if something is different, the person is in a different physical place, that you note it. Because what happens when you read the flow of a record is you see the person checking the box, and if it's always one way and something seems to have gone awry, it could raise a question as to whether I was just not even asking. But if indeed, that can still happen, but if indeed there's an exception, and there often are, I'm not in my, I'm not in my apartment, I'm actually at work in my office today, it's good to note that, but I'm certainly not against, and I'd be interesting to hear, Joe, what you think, and Lisa, what you think, but I'm not against having it be more efficient.
Mm-hmm.
Well, I personally would keep writing that. I think it's important, especially as insurers and other entities are going to begin to differentiate, assuming these waivers go away or they start to get attenuated. There's going to be a question, did you provide the service via telehealth or face-to-face or some other modality? Insurance companies and Medicare are unfortunately often looking for ways to disqualify claims. The nitpickiness can be a problem. So for me, the relative amount of time it takes to write VTC session delivered, with patient at location X, I am at location Y. To me, it's worth it as a way of preventing some trouble potentially down the line.
So Joe, can I ask you if you think there's a checkbox that says in-person, telehealth, in space, that Medicare is likely to have a problem with that?
Well, you know, the issues that, there have been differentiations between audio, video,
Yes.
and,
Yeah.
and phone, for example. So you want to make that distinction.
Yeah.
There's also distinguishing what's called asynchronous communications,
Mhm.
that don't take place in live time. There's emails, let's say, back and forth, versus synchronous communications, which are taking place immediately live.
Yeah.
And these have implications for reimbursement and other regulatory issues. So if you've got my answer, Dan, is if you have enough checkboxes, it's fine.
Yeah, I agree, but I think it's easy to create a form that does have all those checkboxes, right? Like you can check phone only, VTC. You can even list what platform you're using. You can also create a place for you to write where you, the therapist, are and where the patient is located. So I think there are ways to get all of the data, which I completely agree with you, Joe, that is important data. And you know, I wonder if at some point, you know, when insurance companies start, you know, looking at this more, they are going to be looking for that documentation. So I think it's really important to put the documentation in there. And there may be ways to really streamline that too. So, okay. Another question. I have stopped administering IQ tests since the pandemic, since I'm unwilling to sit across a table from someone for an hour or two, even with masks. Are there any IQ tests that we can use via telehealth that do not require in-person administration? And then it talks about some of the Wechsler memory scales. So we can't get into like specific tests, but maybe you can give a little guidance for how to think about this in-person testing, not what we can do, that kind of thing. Joe, do you want to start that one?
Sure. I mean, the gold standard in terms of having to justify your use of the test and the way that you used it comes from the publisher. The publisher's manual and their guidance that they put out is really the gold standard as to whether you did comply and can say that I gave a standardized and acceptable administration or not. So ultimately, the answer has to do with what the test publishers say about this. So Q Global, PAR, iConnect are platforms that allow video administration of tests remotely. And I have heard, I can't say for sure, but I've heard that there's one subtest. Obviously, block design can't be done remotely, but there are substitute tests that can be substituted for block design. So I'm not 100% on this, but the way I'd find the answer would be to go to the test publishers, and they put out reams of material about this, even to the extent of putting their manuals and their stimulus materials online for clinicians to be able to use for remote purposes. So test publisher is where I would go to satisfy myself that it's good enough.
Great, thank you. Dan, any addition there before we move on?
I think Joe's right about that. That's where we've got to turn at this point. And we're, you know, doing full bore, you know, IQ tests right now for many of us it's just not feasible. And there are some substitutes, but we've really got to be sure that they're reliable and valid, and the companies are saying, yes, you can do this, and that's a reasonable administration.
Right. And then again, not to sound like a broken record, but documenting those judgment calls, right? When you decide to use a test, why, all of that, you know, like you were getting at, Joe, how it's valid and reliable, or how it isn't, what the limitations may be given the method that you're using.
Right.
So, okay, next question. This is a hypothetical. If a client does not want to return to in-person work because they're afraid of COVID risk, and they ask me for, so this is work, not therapeutic work, but employment work. And this is actually a question I know I have fielded many times on calls. I bet you guys have too. But so if a client doesn't want to go back to their employment because they're afraid of COVID risk, and the client asks the therapist for a letter stating that they cannot return to work because of anxiety related to COVID, can or should the therapist write such a letter? This particular author is saying, I don't feel comfortable writing that kind of letter as it starts to enter into the FMLA and short-term disability, but they're really curious to hear our thoughts. So Dan, you want to jump in first on that?
Yeah, you know, this in some ways, so this is similar to the questions that we've gotten about, you know, should I write a letter for ESAs or for disability? And there are a number of risks associated with it. There may be conditions where it would be reasonable to do, so it's not something where it's completely forbidden, but the possibility of a multiple role, of stepping into a quasi-forensic activity, essentially here it's higher stakes because you're either limiting a person or allowing them to get access to a resource, which is to be able to stay home from work. And when the clinician is uncomfortable and does not have the appropriate data, if it's all self-report and we haven't done, assessments of malingering, I'm not so comfortable doing this, right? Now, that's the situation, and in many circumstances, I think it would be appropriate to say, no, I don't do those kind of letters. But you may have some other situations where you've worked with a client or patient for many months or years. They have multiple fears. You've got lots of data talking about, the information from them and even maybe from others suggesting that there are significant limitations on their ability to interact because of social phobias or fears of other things, where you may feel comfortable as a clinician saying, yeah, these are my data. I feel like I can write that letter. But I think it's important to be very explicit about the limitations of those data and to be very clear about what one can and cannot say. You may be more confident, or I may be more confident in the accuracy of the information I'm getting, but I still haven't used any kind of objective testing process. I still have the problem of a potential multiple role and conflict of interest. So, on balance, I would only do this kind of thing with great caution and consulting.
Great, thank you. And Joe, if you have something real quick, I'm just noticing time and I'm hoping to get through a couple more questions here.
Yeah, I don't think I would write such a letter. At most, I would write a clinical summary just describing the person's condition. We just don't have the competence to know or the knowledge to know exactly how their COVID anxiety is interfering or interacting with their work. And we shouldn't be making judgments about things that we don't know.
Yeah, I agree. I think it's very risky. Okay, another question. If you are working remotely, so this is related to interjurisdictional telepractice, if you're working remotely through the current COVID experience and you, meaning the therapist, go to another state for a 2-week quote unquote getaway and you work from that other state, but you operate under the laws where you are licensed, so the state where you were, not are, and your clients reside in the state in which you are licensed while you give those services, even though you yourself are out of state, is this considered practicing within the state of licensure? And I think this is interesting and also potentially complex with SIPAC. So Joe, do you want to jump in on that first?
Yeah, I mean, I think this is just kind of often unclear in the rules. State laws and state regulations just don't contemplate if you're going to be in another state. They haven't written a contingency or a rule for that. So there's a lack of development in the law on this issue. I would say that as a practical matter, the risk is quite low, very low. That it doesn't really matter where the transaction is occurring. It's occurring in cyberspace is where it's really happening, and so I don't think that it would be a major problem for a board. I've heard of occasional cases where there's been some issue, but it's been very limited and very peripheral. So as a practical matter, I think you're probably okay, especially during this pandemic period.
I think that's true, although I do think right under SIPAC, I think it is very explicit in SIPAC, and please correct me if I'm wrong, that the clinician, if you're practicing under the e-passport for SIPAC, you have to be in your home state in order to do it. So I think you actually can't be outside of your home license state if you're practicing under SIPAC. So that's the only, I think, change. Otherwise, I completely agree. Dan, Joe, any other comments there?
Why don't we go on to the next question?
Okay.
We have time.
Yes. So one is, am I correct to assume if it is just client preference, that is not a sufficient reason to pursue in-person sessions?
Yes, I think that's true. I think that we need to go through as clinicians an analysis, the ethical analysis to which we have referred a number of times in the roundtables, risk analysis, and also the notion of, is the person in a high risk category for health, for health issues? Are their family members? and documenting, you know, the reasons for seeing somebody in person. So I don't think just preference alone. If there's a reasonably compelling clinical basis, then yes, you can proceed. But I don't think it's just the judgment or the preference of the client or patient.
Mm-hmm. I agree. And probably the last question we'll try to squeeze in here. We'll see how quickly we can get it done. It looks like the basic, without reading the whole question, the basic issue is, do we, when we do telehealth, do we need to get actually signed, written, informed consent? Or is it okay to go with verbal consent of the patient only that then we would document in our chart? Joe, do you want to comment on the risks of that?
Yeah, for the most part, signatures are just evidentiary. They serve to show the evidence that the person read and understood something, but they're not the only way that that can be demonstrated. Evidentiary evidence can be demonstrated by writing in your chart, patient discussed with the informed consent, agreed, did not ask any questions or understood it, and so on. So for most documents, there are multiple ways to indicate and convey that the patient understood and had an opportunity to ask questions about the document. Where that might not apply is in release of authorizations, release of information requests, where some form of signature may be necessary to validate, given that you're disclosing records and that's a higher risk activity.
Mm-hmm. Dan, any addition there?
Yeah, and I want to emphasize something that Joe just mentioned, which is that the signature is elemental, and it's a very good idea to get one if at all possible. So even though you may be able to not do it, you don't want to be in the position of it being the only piece of info you have when somebody's really in high conflict with you. In addition, there are many alternative ways to get remote signatures. There's the, you know, there's a e-sign act. It's a federal act that allows all kinds of different signatures, and a number of state acts that do the same.